welcome back to another episode of Composed Living with Elsa Elbert. I am your host, Elsa, and today my guest is Natasha. Natasha Carroll Ferrary is an estate planning, probate, and trust administration attorney based in Los Angeles. She's passionate about helping families think through some of the most complicated issues relating to incapacity and death, and helping people navigate the legal system while grieving. Natasha grew up in the San Francisco area, went to UC Berkeley for undergrad, and then New York Law School. During law school, she did volunteer work for the Innocence Project, a cause that she continues to support. She became a licensed California attorney in 2008, starting her career as a litigation attorney. And in 2018, Natasha transitioned to estate planning, probate, and trust administration. And in 2022, launched her own practice, NCF Law. Welcome, Natasha.
Thank you so much for having me.
I am so excited for this. I feel very passionate about the work that you do, and I'm so excited just to have like an open conversation where people can learn more about what you do and learn that like it's not scary.
That's my hope as well.
Yeah. Okay, so tell us, I guess, a little bit like what does a trust administration attorney do? How did you get into this? And then we can kind of get into the nitty-gritty about why I love this topic so
Sure.
much.
So I think the thing that I like to explain is that I really help families prepare for incapacity and for at the time that they die to make sure that things are as streamlined as possible and that there are the least legal hitches along the way. One of the things I love the most is helping grieving families deal with all the legal stuff so that they can focus on the grieving part. But also, it's helpful if they have a plan in place before they've gotten to that point so that there is a trust, that can avoid probate, which I'm sure we'll talk about more, and that things are as easy as possible from a legal standpoint.
So I love this topic because I feel like you cannot spend so much time organizing the day-to-day of your life and completely overlook what's going to happen towards the end of your life, whether that's for you or a partner, anyone else that you might be caretaking for. And it's just such an unnecessary burden, I think, that so many people carry. Because even if you don't want to talk about it, like if you're not comfortable talking about death or grieving, like you just want to block it out of your mind, it will happen to everyone at some point. And so it seems kind of absurd that we're just ignoring this entire chapter of life, which, with every passing day comes closer. So I just kind of want to like remove the morbidity of
Yeah.
it. Like it doesn't, I love thinking about like the most beautiful way that I would like my life to end. Not that I'm like rushing it along, but if I had any semblance of control over how that would look, it would not be that I've left my family to deal with financial insecurity or that they're struggling trying to figure out paperwork or probate courts or any of this. I would love for that to just be like a peaceful, seamless transition for them and maybe like a nice surprise, you know? Yeah. Like instead of like pain and misery of paperwork, it's like, oh, she left me a car or like something nicer.
Yeah, I think that's a really nice way to look at it too. It is about organizing everything so that your family is not wondering and not having to deal with the court system and everything. I think that's part of what this whole process is. And it shouldn't feel morbid because it is about making sure that your loved ones are cared for rather than about, anything else. It really is that. And partly it's about, to dive into a little bit of the details of things, but every state has their own rules for estate. In California, the thing that we try to avoid the most is dealing with probate court because our probate court system is particularly arduous. And so part of what the estate planning process is about is avoiding probate court, both for incapacity and for the time that you pass away so that you don't have to go to court.
Can you explain just like in the simplest terms what probate court is?
So probate court is just the name of the court that gets involved. So people know family court, they know traffic court, and then there's probate court. And probate court essentially comes up at two particular times for most people, and hopefully never. But if you've not done any planning in advance and you are ever incapacitated, so that could be short-term incapacity, you're in a car accident, you're in surgery under anesthesia, and then there's long-term incapacity like Alzheimer's, dementia, things like that. If you've not done any planning in advance, then a loved one goes to probate court to get the right to be able to make financial and healthcare decisions on your behalf while you are incapacitated. So the way to get around that is by having a healthcare power of attorney, also called an advanced healthcare directive, or a financial power of attorney, which is also called a durable power of attorney. So that sort of handles with probate court during your lifetime. If you die in California with no will or only a will, then everything goes through probate court. And that means probate is tasked with figuring out your assets, your debts, your heirs, and transferring title into the name of somebody who's alive. And the reason why it's so awful in California is because it often takes 18 to 24 months before anyone gets anything. It's a public proceeding, and the cost of going through probate is a percentage of your gross asset. So if you own a house, it's the value of the house rather than the value you own because of a mortgage. And that's set by the state. So nothing you can do about it. And so that's particularly awful. And it's a lot to face if you have a loved one who dies.
So, a few questions to really drive home the point of why people want to stay out of probate court. If it takes 18 to 24 months for anything to settle, and I have, let's say, a $10,000 a month mortgage, who's paying the mortgage to make sure the house doesn't go into foreclosure during that 24 months?
Usually a loved one will pay it. A lot of times if you are in this, I mean, sometimes it has to be sold, because one of the things that people don't quite understand about dealing with probate is that each individual person has their own assets and their own debts. And that means that, for example, if somebody owns a house and they have significant medical expenses, then sometimes that means that the house needs to get sold to pay off those debts before anybody's going to get anything. And I've had people say to me then, oh, but she left me the house. But she only left you the house if it's there. And the requirement is that she's got to have her assets and debts have to be evened out before anybody's going to get anything. So that's really important for people to understand, because you're not entitled to everything that is in a will necessarily, because there are debts sometimes. So to answer your initial question is either somebody pays it and hopes to be reimbursed by the estate if there is money in the estate, or they don't pay it and you sort of hope that foreclosure doesn't happen too quickly. And many times foreclosure takes so long to actually go underway because there are a lot of protections in place. But it is a risk that often families do have to face. And you're right that it can cost a lot of money up front then for somebody.
Yeah. I mean, like, my kids are still, they're not small. So it's, one of them is a young adult already, right? So she would sort of be responsible for taking over these things, but she's not really like ready for that responsibility. That was one of my big driving factors. And like, I don't want an 18-year-old and a 20-year-old to deal with trying to navigate all of this, nor would they be able to take on the debt load of our mortgage or a car payment or any of that on their own. There's absolutely no way that they would be able to, and there wouldn't be anybody else to help them with that. That was one of the key driving factors for Chad and I in not just having a will. So the second question then is, you said if somebody doesn't have a will, or even if they do have a will, but that's it, they'll still end up in probate court. Meaning, even if I wrote out a will and said immediately, I want all of my jewelry to go to my daughter, I want the house to get split between the three of them, and I want the car to go to this person, that's not just going to happen the day that I die because I wrote it down.
Correct. Any will must go through probate court. And in fact, one of the things that we'll talk about in a few minutes is that one of the ways to get out of probate court is by having a trust in California. And even if you have a trust in California, you are required to lodge the will and tell the court that you are not going through probate because there is a trust. So no matter what, that will is going to go to the court, whether it is used as part of deciding where everything goes or just to say, hey, we're not even going to do a probate because there is a trust in place. So yeah. Yeah.
Okay. So that's good to know. So we do have a trust. We went through the process of setting that up. I will share a little bit about why. One, because I like to check all the boxes.
Important.
But really, it came from a learning experience. I was watching my stepmom, Renee, who I adore. She had a sibling who passed away quite young from complications related to diabetes. And he lived alone and was unmarried and didn't have any children, but he did live out of state and he owned a home and a business, like more than one business. And she sort of became the person who had to step in and try and figure out what to do with everything and how to handle it. And there was no will in place and there was no trust in place. And watching her go through the very long, very complicated process, when, as you mentioned, like she could have just spent that time grieving her sibling or spending time with her family. Instead, she was like going through receipts and scouring his house, trying to figure out like, what did he own? What bank accounts does he have? Did he have any debts anywhere? And that's really difficult. Like, those are not typically things that you share with another person. Like, hey, did you know I have 7 bank accounts? You know, like, we don't talk about that and you wouldn't even know where to find it. He also lived out of state. So she's making like she had to pay his mortgage. She was trying to figure out how to keep the businesses going or to sell them. And it became this really long, very long sort of burden that I'm sure she was happy to do because she's that kind of a person. But I remember watching that and thinking, I don't want to do that to somebody else. I certainly don't want to do that to my kids. And I don't want to be left with that either. Like, if something happened to my partner, I don't want to be left with dealing with that responsibility because that would be the worst time of my life. And then again, I watched her mom, husband had passed away, and there was a complication with like the name on like the mortgage was only in his name, but the title of the house or the deed to the house included her name. Something like this, like where it became sort of like she then couldn't qualify to take over the mortgage because she was elderly and retired and had no income. So she can't qualify for a mortgage. And I was like, no, none of these things are ever going to happen to me or anyone that I know or love because there's no reason for it. Like, if you just take a few hours or even like a full day of your life to make sure that those little boxes are checked off, and it's not, like you're doing the work. I just tell you the information about my life and then you do it. So I don't even have to like file the paperwork to do the thing necessarily. I just think it is infinitely valuable and like really beautiful work that you're doing.
Thank you. Unfortunately, what you explained is so common and it's really sad and it's really awful. And my very favorite thing to say to somebody when they call me and say, a loved one of mine passed away this week is call me back in a month. Nothing that you need to deal with is as important as grieving. But to your point, a lot of times people really want to have those conversations because they're worried because they don't know how they're going to pay the mortgage or pay the homeowner's insurance or pay the property tax bill or, do all of these things. And there's a lot of questions about how that all happens and everything. And if there's no plan in place or people don't know if there's a plan in place, that's also a challenge. So I've also had those circumstances arise where people say, I actually know if they had a plan. And the advice I give my clients is you don't have to tell anybody what your plans say. You don't have to tell them anything. Tell everyone where it's located. Where is your binder of documents? Is it on the bookshelf? Is it under your bed? Everyone should know that because if something happens, they got to be able to find it. They're going to go through all your stuff anyway. So you may as well shortcut them to the old days. So
You better hide all your shit before that happens.
exactly.
Get rid of the evidence.
Exactly. You may as well, at least they just have to go for the binder and they don't need to go through everything else. So that's another important piece is
Yeah.
that yes, do the planning, but also tell everyone that you've done the planning and where it is. I
Yeah.
hate safe deposit box for these documents for that very reason. It's really hard to get in a safe deposit box. There's, misconceptions that that is the best place for it. That is not true. My feeling is the best place for it is wherever people can get to it. And everybody has different comfort levels. And I understand that. Some people want to put it in a home, safe. Some people want to put it other places. I have mine in my to-go bag so that if I need to leave the house, it is one of the important documents I need to take with me. I also suggest that people grab it if they need to leave. And that is kind of the key part is that you've got to be able to get to it when you need it. If you put it in a home safe, tell 5 people how to get into that safe because that's really, really important.
What are your thoughts on storing it electronically as well?
You can store it
Fine, not
electronically, but
fine?
California has not caught up with the current electronic situation. So when you lodge a will, it has to be the original wet
The original.
signature document. If you lose the original wet signature document or it gets destroyed and you are still with us and capable of doing it, my recommendation is always to execute new documents, which is what I did with many of my clients who lost everything in the fires earlier this year. We signed all new documents.
Not that.
So
I'm just going to write that down really fast because I'm like, where's my wet signature?
yeah, super important. Super, super important to know where the wet signatures are.
Is it possible that my attorney who did it would still have it or no, he would give it to us?
Traditionally, a lot of times attorneys would hold on to the original wet signature ones. That is less common at this time because there's liability associated with holding on to the originals. So I would guess that you have the originals.
I bet I have it.
That would be.
We did it several years ago and now I'm like, I was telling a girlfriend this morning, it was like, I kind of feel like I need a refresher just to like remind myself that we did everything right.
Yeah.
But this is a great example of it's definitely not something that I added to our like I have like a fireproof document bag that we do keep with our emergency prep stuff, just since now we live in a climate where we have to evacuate typically once a year. And so now once we're done with this conversation, I will go make sure I have that wet signature.
Yep.
And that it's added to that sleeve of docs. But yeah, I remember my dad, we have very similar personalities, my father and I. And so watching his wife go through what she went through, he was like, and time to have a trust and all these things.
Yeah.
And then he called me and he's like, I want you to know that you're a co-executor of the trust and the will and all the things. And I was like, no, I refuse. Because that need will never arise. I reject it. But, I appreciate knowing that he has always taken the precautions to protect us when we were young children and that he updated it when we became young adults and has updated it again to reflect their current state of affairs and the fact that, all of his children are in their 40s. So we don't need the same level of protections that we did when we were 18.
Yeah, and I think that's important.
And it is nice to know that it's handled. Yeah.
Yeah, I think that's important to note, though, too, is that I do think it's always worth reviewing documents. I usually say every 3 to 5 years. Probably nothing has changed, but there are things that do change that you sometimes don't realize what you did or how you did something. And it never hurts to go through it again to make sure, like, are the people still the people who you want to be making decisions for you if you're not able to do so? Are things going to whom you want them to go, when you want them to go? Have you put all of your assets into the name of the trust? That is a really, really important thing that many times gets skipped. It's also something that is the biggest problem with using online document services that inevitably doesn't happen. And many times, I would say every time I have reviewed a trust that somebody created with an online provider, I will not name names, it inevitably...
Well, no.
There's a couple, but they always end up in court. Always. Either because it was done incorrectly and ends up in probate, because something was, not, it's always because something wasn't done correctly. And that's a really hard thing for many families to accept, that they felt like everything had been handled because their parent did these documents. But there are things that didn't get handled correctly. There are times where people don't realize what they did. And it's really, really painful for the family. And it's really hard as an attorney to have to tell somebody, like, actually, that's not what this document does. So that's my one caution, is to make sure you work with an attorney. There are attorneys at all different price points in the state. There's somebody who you will have a connection with, who will make sense to you, who's in a price range that you can afford, who is an attorney. And that's really important, because there's also a lot of people who are document service providers who will provide documents but are not lawyers. And that is not the same thing as having a lawyer. I believe very, very strongly. There are some areas of law where I might not believe as strongly, but this is one that I've watched it happen over and over and over again when a non-attorney drafts documents. So that's my one thing that I really want to drive home, is that please work with a lawyer.
Yeah.
Please, please, please.
I also think it's so important to have the human connection when you need them in this particular instance. And like you said, someone calling you within a week of a loved one passing, like, who are you going to call if you used like LegalZoom or something? Like, you're not going to have someone there to support you through that process. And I think that part is probably just as valuable.
Yeah, I think that's
it was such a wild ride going through like all the questions you have to answer to set up the trust and like to come up with the will, but also something that like really all couples before they get married or before they decide to have whatever partnership is going to be long lasting for them, married or not. Chad and I didn't have a lot of those conversations, or if we did, it was sort of jokingly, but not really in like a let's write it down and hand this over to the attorney and file this document kind of a way. And I think it was great. Like, sometimes it was hard, not contentious, but just like really, I don't know what the best answer is for some of these things, especially when it was like, how do you want to be buried or cremated? And I was like, I don't know. What's the right answer?
Yeah.
And so taking the time, I think, to think through those things was kind of a special thing to do as a couple, especially when it came to like, we had pretty different ideas on how to take care of the kids at different stages of their life. I think I tend to be more cautious and want to like ensure their livelihood for as long as possible.
Yeah.
So it's not just like throw a bunch of money at them when they're 18. Like, no. Because if I was 18, I'd be like, Nordstrom's, here we come. And then I would be broke by the time I was 20. And so even thinking through like how many protections can you put in place while also making sure that they have a great quality of life, that was such a wonderful conversation for us to have and align on as parents.
Yeah, I think that's true.
And then, of course, that will change again soon, because another one will turn 18 and then another, and then it changes all over again.
Yeah, I think that's true. I also think that the different attorneys work different ways. One of the things that I do is I do not require people to make those decisions about what they want to happen with their remains as part of this process. And I have very strong reasons for this, partly because I think it stagnates people, and partly I think because what I do is I provide people with pretty much blank pages for them to fill out as they want to, when they want to. And my reason for that is because people often change their minds about things like that. So having the space to be able to update it or change it and include whatever details are important to them is important to me. But I also don't want those decisions to stop somebody from getting their will and trust and powers of attorney done, because I do think that's the hardest, most sensitive part. So the documents that I provide for that piece are, who do you want to be notified at the time that you die? What do you want to happen with your body? Do you have preferences for marker selection and urn, something else? What kind of a service do you want? Do you want a big party? Do you want something more somber? What is it that's important to you? And my feeling is handwrite that, because then we know it's you. And then you can update it. And
Yeah.
it doesn't have to be part of the legal documents, so that if you change your mind, you can change your mind on your own without having to go back to an attorney to change that. And that's really important to me, because I do think that's the most difficult thing for people to get through.
Yeah.
And to me, I want to give you those resources, but I also really want to make sure that you get those core documents done. And so I want to focus your efforts on the deciding on, who's making decisions for you for financials, who's making decisions for you for healthcare, who are your guardians, how do you want things to be distributed, when do you want them to be distributed, what happens when the first spouse dies, what happens when the second spouse dies. And that kind of,
Yeah.
flow is they're hard conversations, don't get me wrong. It's not like that's super fun and easy to talk about. But if I can
Yeah.
limit those challenging conversations, then the hope is to get through it more easily than if we also then have to decide, like, oh, I have to go pick out what casket I want. Like, no, you don't need to do that this minute, but you do need to think about it and
No.
tell people what preferences you've got, because it'll make their lives easier down the line.
Yeah. I love that approach. I think that's really beautiful. And any sort of elimination of those barriers to people getting those core documents done, like you said, is so smart. Again, same girlfriend I was talking to this morning. She was like, "Oh, I got to get that done." When she asked what the podcast was about, I was like, it's my favorite subject.
Yeah, it's true.
And she's like, "It's just like it's like overwhelming." I was like, "It's really not though. Like, it doesn't need to be overwhelming, and you're supported through the whole process." And I was like, just make it a New Year's resolution for next year. Like, that's going to be your January goal, is to get that handled. And, I love that her situation is so different from ours. Like, they don't have kids. So then it becomes a whole other complication of, they're like, what should we do with our stuff? Like, who do we want it to go to? Or what do we want to happen to it? And I'm like, I just have no way to answer those questions for you. That's so wildly different from our situation with 3 kids. So
And I
I
think the
think
thing,
that has been a
what
barrier.
you said is really important, because they also don't have to have those answers before they talk to the attorney. And I think,
Yeah.
different attorneys work different ways. When somebody comes to me, I assume that they don't know anything about what we're talking about, and that they haven't given a ton of thought to anything. And that's often incorrect, but I don't want to assume that anybody is any further along than we want to feel that they are. And a lot of times people through our conversations change what they want to do, or, that it's a little bit different. And especially, when there are couples who don't have children, or they have very specific wishes about charities that they want to, contribute to, or there's a combination of different people who they're concerned about. A lot of times pets play a role in that kind of, caretaking and what they want to happen in that circumstance. And those are all part of the conversation that then, your attorney would have with you about what you want and what you want to happen at both incapacity and at the time that you die. And those are important conversations. So I would say, like, nothing has to be prepared in advance, because maybe something I say triggers something for you to completely rethink what you had in mind anyway. So, take out all the barriers. Just have the first
Awesome.
conversation.
No
No
barriers.
barriers.
Just set up your initial conversation.
And I would say in California, most attorneys do a complimentary consultation, or if they charge for a consultation, they will put that fee towards the plan when you retain. So
Well,
that is there are very few attorneys who I know in California who charge and don't add it to contribute it to the cost of going through a plan.
mhm.
So my hope is that establishes fewer barriers to somebody having that initial conversation.
Yeah.
So
And so, from your perspective, most important thing to have handled would be making sure that you're staying out of probate court and you have some sort of a trust and a will. Is it important to have a trust if you have no assets?
so the most important documents to me always for everybody over 18 is a financial power of attorney and a healthcare power of attorney. Everybody over 18 needs to have those 2 documents. There are state forms that you can use and have notarized. You don't have to work with an attorney. I think that's really important for, like, college students who are leaving home.
Okay.
Your parents do not have the legal right to make decisions for you once you turn 18. They do not. You don't even have to give your parents the right to make those decisions for you if you don't want to. So that's really, really important. I think what follows from that is whether you have a will. A will is helpful to direct what you want to happen with your assets. The threshold to have a trust is, for me, essentially 2 or 3 things. The threshold to go into probate court is $184,500. Okay, $184,500. I repeat that again. So if you have more,
Meaning if you have less than
if
that,
you have less than
no probate?
$184,500, then a will is sufficient. Okay. There's a world in which, for example, if you put a beneficiary on bank accounts, that also is a way to circumvent probate court. So I think
Okay.
that's really, really important. So for young people, I think, put a beneficiary on your bank accounts, maybe a will if you've got some personal property that you have wishes about where you want it to go. But you want to make sure that if you're over that threshold, then you probably need a trust. Are there exceptions? Absolutely. There's always exceptions to that. The 2 biggest things, if you have minor children and if you own property in California, then you will need a trust. It's
Okay.
I can't think of a circumstance where I would tell somebody who has minor children or owns real property that they don't have a trust. I'm sure there's a circumstance that would come in front of me now that I've said that out loud where I would say, actually. So it always depends on your personal situation. It's not a one size fits all situation, but minor children, own property, likely a trust. If you have more than $184,500, then likely you need a trust, but there's certainly exceptions to that as well. So that's what I would say. The will is going to go through probate court no matter what.
No matter what.
Yeah. So
Cool.
that's why I think that makes a big difference, is that threshold amount is gonna matter. If you are less than $184,500 and you've got, and most of that's in personal property that's gonna have to be distributed, then you may have to go through probate for that too. So there's just it's a lot of like, it depends, which is like every lawyer's answer to everything. I'm sorry that it's applicable, but the powers of attorney.
It's true.
Yeah. The powers of attorney, everybody should have a financial power of attorney and a healthcare power of attorney. Everybody.
Okay. That's also such a good reminder. Our middle son will be going off to college next fall and will be turning 18 next summer. So just making sure that he has that in place, especially I think he'll be out of state. So just making sure that has as many protections as possible.
Yeah.
You mentioned having a beneficiary on like a bank account. Is that sufficient to keep things out? Like, I'll do a very real example. Say I have a checking account. If I die and I list one of my kids as the beneficiary, do they just like that become theirs, or there's still like all these years of waiting?
No, there's not the years of waiting. There is usually what banks require if somebody is a beneficiary on a bank account is that usually I think it's a 40-day waiting period, and then they can show up with a death certificate and get the cashier's check for that account. So yes, having a named beneficiary works to avoid probate. The problem arises if something happens to that person and they predecease you and you don't update those accounts. So many times when there is that circumstance, I might say like, okay, name, your child as the first beneficiary and then name the trust as the backup beneficiary so that if your child, God forbid, predeceases you, you've got a backup in place that also avoids probate and gets where you want it to go. So there are different ways of structuring it depending on what your goals are and who the people are in your world. And different attorneys, again, will have different advice for each person. But that's generally the beneficiary will avoid probate.
Awesome. It really, I think it's such a good reminder for me too that like you do it once, you get kind of the bulk of the stuff settled. Like you have the trust set up, you have your will, you have your power of attorney, your financial power of attorney. But then it's still a flexible thing. Like you can change your mind about those things. You can update things as you need to or as your circumstances change. So it's not, like I think that's another barrier is like, what if I make the wrong decision? Or you can change it as you need to.
Yeah, and I think what I like to remind people is that the decision that you're making is the best decision for today. So sometimes people will say, well, my parents would be the best, guardians for my kids, but in 10 years, we're not 10 years from now, we're right now. When your parents stop being the best
Yeah,
guardian, then you change your documents. But if they are the best choice for today, that's who you pick today. I think what you said is really,
that
really
makes
important.
sense.
They are adjustable documents that can change. There's one other thing that I want to mention because I did say the $184,500 threshold. A new law went into place on April 1st of this year that allows a non-probate transfer of a property that is worth $750,000 or less. So,
Okay.
although I said that I generally recommend a trust if you own real property, there is this exception that has come into play this year if the property is worth $750,000 or less. But it
Okay.
only applies to that real property. And if you've got other assets that are, again, worth more than $184,500, you're still going to end up in probate. In California, it's so rare to find a property that is,
Yeah.
so my hope is that it's applicable for people. You still have to file paperwork with the probate court, even if it's the $750,000 threshold, but it's supposed to be a faster process. We'll see.
The air quotes for anyone not watching the video. Faster than 18 to 24
Faster than
months,
18 to 24
which
months. So,
is really not saying a lot.
no.
Basically, the title of this episode is going to be $184,500. And if you get one thing out of this, it's like just hire an attorney to do this for you so that you're not figuring all of these things out, which I think even if you spend the time to do it on your own, it doesn't really alleviate the stress burden and the feeling like for me, background stress is so present in my life. And it's like, I don't want the background stress of wondering if I did it right or wondering if something is going to go wrong or what am I going to have to try and navigate alone in the future. If there is a way I can be supported through that, then I would much prefer to do it that way.
And I think that I got an email last week from somebody who told me that their parents had established a trust through an online provider. I think that they had established it pre-pandemic and they made a point of saying that it had been approved by the online provider. I put that in air quotes because I don't know what that means when it's approved by an online provider. One of the parents died and the surviving parent now would like to make changes to the trust. And when they went to go make changes to the trust, they were told that parts of the trust are now irrevocable, meaning cannot be changed, which was not at all what their parents had intended to do when they set the trust up. But because it had been approved, again in air quotes, by that online provider, the parents were under the impression that the trust was doing what they wanted it to do. And now it's not. And now that there's one surviving parent, usually when this happens, you've got to go get a court order. And this is not an inexpensive fix. Had they started out working with an attorney, then all of the costs that they're going to face to fix this is going to be sufficiently more than had they gone to an attorney initially. The cost is it's extremely frustrating from my perspective to see somebody go through this because now they're grieving a parent and the surviving parent can't do what they want to do. And that wasn't what they wanted. They wanted to
Yes.
help their families and it just didn't. So,
And on top of that, you're adding a significant cost to a grieving family. And the worst part is that it's all preventable and unnecessary.
yeah. And it's stress,
So,
sad, and it's really, really hard when somebody is, grieving and, to find out like, wait, we now have to jump through these hoops. And sometimes it's just like that wasn't what we thought it did. Well, that's unfortunate. The other thing I would say is that I would, a lot of times people set up their trust and they think it does what you want it to do. And if they're not sure, then you should talk to your attorney and make sure that they can explain to you what your trust actually does. There are things that have changed. Very few things change in estate planning, but when they do, they're pretty massive. So there was a period of time where there were trusts that were required to split at the time of a first death, and that was because the estate tax exemption amount was particularly low. The federal estate tax, California doesn't have an estate tax, so I can dive into taxes, which everybody loves. But so the federal estate tax was low, so most trusts required a split at the time the first spouse died. Now the estate tax exemption amount is $13.99 million per person. So a married couple has $27.98 million. It's going up to $15 million on January 1st, $30 million for a married couple. So those splits that were initially established to avoid an estate tax, they're just not necessary for many, many couples at this point in time. And I would suggest having those reviewed by an attorney and perhaps restating the trust so that it is a simpler outcome at the time the first spouse dies. I think that's really, really important because people just don't know what they don't.
Yeah, I had no idea.
Yeah.
And now I can't stop picturing my trust splitting in half. And I'm like, but what goes into each half? It's a great visual.
Yeah.
I'm adding that. I have like my list of notes, even though I have clearly this as a video. I'm like, follow-up question.
Yeah.
And I know that we have beneficiaries on our bank accounts and things, but now I'm just going to do just a little double check,
Yeah.
Never hurts. If you think you left the stove on, never hurts to go back and look.
I agree. That is a really, really important. Check all assets. You want to make sure that they're either in the name of the trust or that there's a beneficiary on everything. And again,
Yeah.
partly it's going to depend on how your attorney drafted it and what your attorney recommends. So I don't want to try to give any kind of legal advice on here about what to do, but I would just
Sure.
make sure that you confer with your attorney, make sure that, if you've got a trust in place, that the assets are actually in the trust or the trust is a beneficiary, depending on what you talked about with your attorney. That's really, really important. If you have a trust in place and you have an asset that is not in the name of the trust and doesn't have a beneficiary, that asset is going to probate court if it's over $184,500.
And the first thing you said at the start of this episode was, let's all stay out of probate court.
Exactly.
So we do not want that. Yeah, I mean, I see it when we get mail for our house or our mortgage. It's like whatever the name of our trust is. Is it important for something like an automobile? Like, let's say you own a car outright. Like, is that something that's necessary to be in a trust?
Usually not. If it's a collectible car, like something like that, that's a different circumstance. But daily vehicles, California's DMV may be very bad at a lot of things, but they are amazing to work with when somebody dies.
Okay.
So no, those usually cars don't usually need to go into a trust for any reason. You can just have one person.
That's good to know.
You can also have joint ownership of automobiles in California. So if you own something outright, then sometimes it's helpful to have both spouses' names on there. Just less thing to deal with.
Awesome. Wow. So much good advice. I have my little checklist now of things that I'm going to review. And so people understand how they can work with you. Of course, you can do the whole process of helping them from start to beginning. But for someone like me who feels as though like the foundation is already there, do you work with people to do sort of like a refresher or a checkup kind of a thing? Like make sure everything is accurate, especially if, let's say, they did do things on their own?
Yeah. So if there's a couple different things. So what I will do with a potential client is review their documents with them, let them know what their documents do, what they don't do, and talk through goals and see if they do want to make updates. One of the things that we as attorneys are not allowed to do is amend a prior attorney's work because we take on the liability of any mistakes that attorney did. So if you just want to make some changes, then I generally tell people your most cost effective is to go back to the drafting attorney because they can amend the work in a way that I cannot. That doesn't mean I can't work with somebody. It just means that it's sort of like starting from scratch with me. So I would do what's called a restatement of a trust that retains the same name and the same date of the trust. So any assets that are in the trust, you don't have to touch them. And basically, it's like keeping the name and the date the same and then gutting the whole trust and sort of starting over. But you do then need to redo your trust, your wills, your financial powers of attorney, healthcare powers of attorney. So I don't know I don't think I know any attorneys who will amend another attorney's work. It's a high
That makes
liability
sense.
situation. I will not review any online created documents. That is my personal policy because I can't even begin to guess what was inputted and all of that stuff. Usually when I have somebody who comes to me to say, like, we did this and we realize we shouldn't have, then I will look at the document to see the name and the date of the document. So again, we keep the name and the date of the trust the same. So if there are assets in the trust, but essentially we're just going to start over and pretend this didn't exist. And that way we can kind of rethink things. I can talk them through the different options, based on their circumstances and what I might suggest depending on their family and what's important to them and their goals and things like that.
Awesome. That's also helpful to understand. Thank you so much. It was so informative. I hope that we've inspired at least one person to eliminate the barriers to getting this handled and just get it done and feel good. Feel that relief that comes from knowing that you've sort of preemptively taken care of your loved ones in this way.
Yeah, I hope so too. Thank you so much for having me. I'm happy to talk about this all the time.
I know. Same. I feel like you and I have already had this conversation. It's like, but truly, I just get so excited about it. And I think it's so valuable. The service you provide is just, it's extraordinary. And I appreciate the work you do. And I'm so happy that we connected in this way. And thank you for being my guest.
Thank you so much, Elsa.